blissful moment to you all. You're welcome to today's episode of Catching Up with the Law. Quick one. If Mr. A sues Mr. B for trespassing on his property, okay, let's use a pen. If he sues Mr. B for trespass to chattel, claiming that this belongs to him, and subsequently Mr. B could not prove that this pen actually belongs to Mr. B, will the claimant succeed in a case merely on the failure on the part of the defendant to prove that this pen actually belongs to him? My name is Adam Mary Uche Esquire, and that is why we have this forum. I've brought up this platform called Catching Up with the Law. Now, when a party is claiming declaratory reliefs, the success of his claim is not dependent on the failure of that of the defendant. The claimant must lead credible evidence to prove that this pen actually belongs to him before he can succeed in that claim, irrespective of the admission of the defendant. He must prove beyond reasonable doubt. Preponderance of evidence. That's a topic for another day. Beyond reasonable doubt has to do with criminal evidence. This pertaining to civil litigation is on the preponderance of evidence. Okay, now to buttress this point of mine, there's this very recent case that happened on the January 14th, 2022, and that's this year. It was decided in the Court of Appeal, Ebong and Ebong to be precise. It's a case where two cousins were at loggerheads over a said property. The first cousin was claiming that the property it's emanated from the High Court, and then the case was upheld. The case was held in favor of the defendants. Then the claimant appealed to Court of Appeal. In that case, the claimant was claiming 4 declaratory reliefs. The first one was the statutory right of occupancy over the land, and also he was suing for trespass of the defendant on his property, because he said that he did not grant consent before the defendant went ahead to restructure the property on the land. And also he was claiming mandatory and perpetual injunction, and finally he was claiming 6 million naira. Okay, to give you a rough sketch, it happened that the father had passed on, and the claimant claimed that the land was bought for him through his dead father. The defendant, on the other hand, said that the father gifted him a portion of the land on which he erected a concrete. That before the case emanated, that the claimant actually built a wattle house for him and his siblings, and so he had to restructure it to concrete. You get the point? So the claimant issued him a notice to quit because he did not seek his consent before renovating the property, and that's why they went to court. However, the claimant could not prove, there was no tangible proof, no credible evidence to buttress his point that the father actually bought the property for him, because the landed document had nothing to do with his name. It only bore the name of his father and the vendor. While the defendant was unable to prove that the property actually belongs to him, and there was no deed of gift whatsoever to prove that the father of the claimant actually gifted him the property. The court upheld his own, like the court ruled in his favor because of the fact that whoever is laying claims, declaratory reliefs to a property is actually a discretionary right of the court to grant, and you must be able to lead credible evidence irrespective of the failure of the defendant's proof or evidence. And also, that was when he was aggrieved, and then he appealed to the Court of Appeal. And on January 14th, 2022, the court upheld the decision of the lower court, that is the High Court, holding that the claimant could not lead credible evidence to prove that the land belongs to him. So, tilted back to the favor of the respondent, which was the defendant in the High Court. So that's it. I will bring you more. I'll bring you subsequent law reports. I'll make sure I keep you abreast with the law, and that's how you can catch up with the law. So, see you next time. Bye. My name remains Ada Mary Uche, Esquire. Ciao.